Today, good afternoon, everyone. Thank you for joining us today. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. Today's Monday. Day. Good afternoon, everyone. Thank you for being here today. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. Today is Monday, June 15, 2020, and the time is 2:05 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Monday, June 8, and again on Thursday, June 11, 2020. Notice was also published in the Guam Daily Post on Monday, June 8 and Thursday, June 11, 2020. This Zoom meeting is hosted by the legislature's MIS staff and my staff, and I thank them for their assistance. The host of this hearing will mute all Zoom participants until called upon by the chair. Members of the committee and the legislature wishing to speak may indicate their desire to the chair through the in-app chat feature. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. When called to speak, please ensure that you're unmuted. The order of questioning will begin with the chairperson, followed by the senators for each agenda item. Each member will be allowed to pose a question for one round, and we will proceed with multiple rounds as needed. Questions and testimony shall be confined to the substance or nature of the agenda. Personal inference as to the character or motive of any senator or individual testifying is not permitted. Any violations of this general rule of conduct will result in removal from the public hearing by the host. So we have 4 agenda items today, 4 different bills. The first is Bill number 277-35. This was submitted, introduced by the Committee on Rules by request of Imagahagan Guahan, the Governor of Guam, in accordance with the Organic Act of Guam. It's an act to add a new Article 5 to Chapter 4, Title 19 of the Guam Code Annotated, and to recodify 18 GCA 90113 as a new 4502 thereof, relative to establishing criminal liability for failure of a parent or legal guardian to exercise reasonable care, supervision, protection, and control over their minor child when such act or omission permits or encourages the minor child to commit a felony or misdemeanor crime. Second item on the agenda will be Bill number 310-35 COR, introduced by Senator Talina Nelson, an act to add a new Chapter 93 to Title 9 Guam Code Annotated relative to holding parents accountable for the harmful actions of their children. Shall be cited as the Parent Accountability Act of 2020. The third item on the agenda is Bill number 275-35. It was introduced by the Committee on Rules at the request of Imagahagan Guahan, the Governor of Guam, in accordance with the Organic Act of Guam. It is an act to amend subsection A of Section 80.70, Chapter 80, Title 9 of the Guam Code Annotated relative to prohibiting parole for violent and sexual offenses. The fourth item on our agenda is Bill number 278-35 COR, introduced by Committee on Rules at the request of Imagahagan Guahan, the Governor of Guam. It's an act to amend subsection B of Section 60.80, Chapter 60, Title 8 of the Guam Code Annotated relative to prohibiting plea deals without reasonable proof of victim notification. I'd like to acknowledge the presence of my colleagues here today, beginning with the Vice Speaker, Nelson. Thank you for being here. Senator Kelly Marsh Taitano, Senator William Castro, Senator James Moylan, Senator Luis Muña, Minority Leader Senator Terlaje. Thank you very much, colleagues, for being here today. So we will begin with the first item on the agenda. This was the bill introduced at the request of the governor relative to establishing criminal liability for failure of a parent or legal guardian to exercise reasonable care, supervision, protection, and control over their minor child when such act or omission permits or encourages the minor child to commit a felony or misdemeanor crime. All right, so we've got signed up to testify on this bill, the public defender, Attorney John Morrison. You may begin. I'm sorry. Normally we have the sponsor introduce the bill, but of course this bill is introduced by the governor or by the Committee on Rules at the request of the governor. And I will just, I'm going to just very briefly summarize the bill. So the bill, Section 1, adds a new Article 5 to Chapter 4 of Title 19. Article 5 would be titled Duties and Obligations of a Parent to a Child. And it lists one section of the law, a proposed section to the law, which says, which defines a parent's or guardian's duty to, quote, exercise reasonable care, supervision, protection, and control over their minor child. If parents by act or omission fail to exercise reasonable care, supervision over their child, resulting in the child committing a felony or misdemeanor, then the parent can be found criminally liable with a fine up to $2,500 or up to a year of imprisonment or both. And this would be placed in Title 19 of the code where parent and child relationships are defined. All right, and now if Attorney Morrison, you may proceed.
Thank you, Senator. Committee members, I think generally in our system of law, the government seeks to punish people that commit an overt act with a malicious intent. That's basically simplifying things down a great deal, but I think that still holds true. Would have no concern about a law that would punish people for contributing to the delinquency of a minor or in taking some overt act therein. However, my concern with this particular law is that it allows for the criminality of omissions. So the concern here is that a parent or parents may, due to their exhaustion raising their children, fail in some respect and then inadvertently become criminals themselves. Again, without any overt act. It would, of course, be the Attorney General's prerogative to determine when the omission rose to this level. However, I think it's a slippery slope, and I think we could end up in court on these types of cases where the parent is really trying their best to raise their children, to provide for their family, to work. That's taking them out of the house frequently. And a 17-year-old child or in that area gets out of the house and into trouble, thereby making a criminal out of the parent. So we do have concerns that it would be misapplied to those that are more poverty-stricken and don't have the resources that other people would to make sure that their children are properly taken care of. I don't have anything else to add relative to this particular bill.
Thank you, Attorney Morrison. I'd like to recognize the presence of a couple more of my colleagues, Senator Regine Visco-Lee, thank you for joining us, and Senator Mary Camacho-Torres. Thank you, Senators. Senator Lee, there's no one here from on behalf of the governor to introduce the bill. I was just wondering if Committee on Rules had anything to add in introduction.
To Dusmasi, Madam Chair, we also have not received anything from the front office on this. And yes, it was sent to our office, and the typical process is for us to introduce on behalf of the governor. But again, we haven't received any opening statement that should be read into the record. Should one come down, though, I'll be sure to alert the committee and my colleagues. Thank you.
All right. All right. Thank you very much. And with that, there's no one else signed up to testify on this bill, and I'd open the panel to my oh, I'm so sorry, Superintendent.
Yeah, I apologize. I just wanted to, I did put it in the chat. I know you had a deadline last week, but we failed to meet that deadline to notify you. But we did intend to provide testimony on both 277 and 310. Actually,
yes. No, you're right. My mistake.
Okay, Ms. Carla Borges, also the parent representative on the board, and she's here as well when you're ready to receive our statement. Yes,
please. And welcome, Mr. Superintendent and Ms. Borja. Thank you very much for being here. You're here on behalf of the Board of Parents. If you could, well, please introduce your parent representative to the Board of Education, Ms. Borja.
Yes. Yes.
Great.
Yes.
All right. Wonderful. Okay. All right. So please proceed with your testimony, whichever of you wants to go first.
Dear Chairperson Terlaje and members of the committee, I want to thank you for the opportunity to provide testimony on Bill 277-35, introduced on behalf of the Governor Lou Leon Guerrero of Guam, and Bill 310-35, introduced by Senators Talina Nelson and Amanda Shelton. Both bills propose to create a consequence for parents whose children commit or incite certain offenses against other individuals or against property. In October of last year, we had the opportunity to address the issue of student safety before an Education Committee roundtable. And indeed, we did ask for the legislature to consider strengthening the laws around parental accountability as one of several strategies to combat recent incidents involving riots or fights at several high schools, as well as the threat of weapons on campus. At that meeting, we clarified the continued need to provide positive supports to our students to avoid these consequences. But we also asked about drawing a clear line when it came to consequences. At that time, we talked about fully leveraging the authority of the department to expel violent and disruptive offenders from school, as well as imposing consequences on parents and guardians for failing to intervene or prevent such offenses. With this said, the timing of this hearing has been less than ideal due to the fact that it is taking place after school is shut down and in the midst of our efforts to focus on recovering from the COVID-19 pandemic and preparing to reopen for the coming school year. We would like to request an additional 10 business days to share the legislation with our parent-teacher organization.
Just a minute, I can't hear you. Okay, please proceed.
We would like to request an additional 10 business days to share the legislation with our parent-teacher organizations and our school officials in order to provide the legislature with not just input from the board and management team, but also our schools and parents. We do support the notion of consequences for parents who fail to properly supervise and guide their children away from committing criminal acts. But it would be helpful to gauge the level of support or concern regarding the specific consequences being proposed. We know that this coming school year will be far from normal, with the possibility of staggered school attendance, which should lead to lower numbers of students physically on campus at any one time, which we hope will contribute to safer campuses. In addition, we know that parents will also play a different role in supporting teaching and learning at home, as well as supervising students during their days away from the physical campus. We will want to evaluate the proposed legislation in this context as we provide input to you for your consideration. Thank you for this opportunity to testify before you. And we also want to thank you in advance for considering our request for the additional time to provide a full response to both bills.
I appreciate that testimony. Vice Speaker, if we're going to talk about both bills, I would like to give the opportunity for you to introduce the bill, and if it's okay with you to talk about them both together, or we could just proceed with the superintendent's testimony.
Whatever you would like to however you want to move forward with the hearing, just let me know.
Well, why don't we do that so that they're going to be talking about both bills. Naturally, if as a sponsor, I'd allow you to introduce the bill, please.
Okay, thank you very much, Madam Chair. Okay, Bill number 310-35 LS is an act to add a new Chapter 93 to Title 9, Guam Code annotated, relative to holding parents accountable for the harmful actions of their children, shall be cited as the Parents Accountability Act. And Madam Speaker, this bill has been a working product since the beginning of this term. We actually took a look at it last term as well. However, it was very difficult to move forward and to really get a pulse on how the community felt about holding parents accountable for the actions of their child. We wanted to find ways in that we understand that it's parenting is difficult. I'm a product of that, but we wanted to find an avenue that we're allowing the parents to step up and accept ownership of their child's actions. Just last year, we had several riots that occurred, and there have been, in accordance with the Student Services Support Division academic period, August 17, 2017 through April 30th, 2018, there have been fighting, an event count of 626 under the event description of fighting, reckless conduct, 535 counts. And so these are individual behaviors. This is what they're accounting for that have occurred. Assault and battery, 484. Instigating a fight, 305 counts. Physical contact, 126 counts. Rioting, 95 counts. Property damage, 65 counts. Vandalism, 63 counts. Terrorist conduct, 36 counts. And graffiti, 13. So this is just a general breakdown of what we received from this report. We're not talking about every other thing, such as possession of alcohol, abusive profanity, contraband, deceptive behavior. So, we're just pointing out the most violent behaviors in this instance. And so it is not new within our jurisdiction that there are current parent accountability laws. In some states, such as Alabama, there's a $1,000 fine for parents or guardians liable when a child causes intentional, willful, or malicious destruction to real person or property. In California, there's a $25,000 fine and a $25,000 for property and a $25,000 medical dental hospital costs for parents jointly and severally liable for willful conduct causing injury, death, or property damage. And so Colorado, there's another fine for $3,500 for liability imposed on parents for child shoplifting or willful malicious property damage or personal injury. And so these are just some of the things that we've looked at to find a way to address this issue within our island. In this bill, there are fines proposed. However, it also provides an avenue for the courts and the parent for the fees to be waived if the parent is willing to move forward and if there is proof that the parent did not take part in the act of the minor. But also, in a way, we're looking to see if we can look for a holistic approach and see if we can also mandate family counseling for the child and the parent to make that waiver option rather than having to pay fines and fees, and also perhaps anger management. Just depends on the action of the child. So thank you, Madam Chair, for allowing me this time. And Madam Chair, I do want to say just one more thing. I have reached out to several PTOs and also to the superintendent. And, I want to thank him for, even being present today. He asked for a little bit more time if we could hold the hearing at another time because Right now, they're really bombarded with the summer school program and the impacts of COVID and how we're going to plan for the upcoming school year. So if we could kindly please allow them that extra time to submit further testimony, so that we can hear their thoughts and we can see how this legislation will be impacted by their testimonies. Thank you, Madam Chair.
Thank you very much, Vice Speaker. And Superintendent, I will, if you would like to make any comment on this bill. So so for my colleagues, just to be clear, so we talked earlier about the bill that was introduced at the request of the governor, and that bill number was 277. We are now discussing, in addition to 277, bill number 310, which was introduced by the Vice Speaker. And DOE's comments are on both bills. Superintendent, and thank you for submitting your testimony in writing to my office. I appreciate that. Please
okay,
proceed.
thank you. Thank you, Madam Chair and members of the committee. And Ms. Borja read the written statement that we submitted already, and we do appreciate the opportunity, if you would allow us additional time. Normally, as you know, when there is a situation where there is legislation that is as important, but also potentially might be controversial to our stakeholders, we tend to reach out so we can gather the input from our employees, our teachers, our counselors, as well as our PTO representatives. So unfortunately, with the school year cut short and in the middle of that planning, we weren't really able to do so immediately upon receiving notice. But we do have a PTO representatives meetings scheduled. It's a virtual meeting, and it'll be scheduled for this Thursday. I believe it's at 3 p.m. So we're sending the legislation out and soliciting their input and discussion. So what we plan to do is similar to what you're doing, just explain the bills that are before the legislature, and then open the floor for discussion, so that we can have a very an updated input from our stakeholders. The reason I say that is because of a couple of things. I think number one, when we met in October, we were really trying to respond and be very clear about what was happening in our schools relative to the riots that we were seeing early in the school year. I know you remember the one at Tizen, there was one at JFK that were caught on video and circulated, and we were really trying to prevent and ensure that there was a clear line drawn in the sand about what would be tolerated at school and what should never enter our campus. And parental accountability was not the only strategy, but was one of several strategies that we had proposed in order to try to not just provide positive incentives to our kids to behave at school, but also try to provide disincentives to encourage more supervision of children on campus as well as off campus, as part of that more holistic strategy to prevent these kinds of occurrences from happening, especially where violence is concerned. So we definitely do support and appreciate the measures that have been put forward. But what we really would like to ensure that we've had a full discussion with our parents as well, because we do recognize that it is a tough decision. I mean, a tough job to be a parent and to supervise kids and to try to make sure that they don't make any mistakes along the way. But at the same time, we know that the violent kids in our system represent such a small minority, and we get that pushback from parents who are saying, we need to say enough is enough. And so trying to really find that balance is important. And the other reason why I think it's important to update the input is because of the new situation we're in. And I'm really very sensitive to that, because as we head into the next year, we are going to be asking a lot from our parents in order to adjust to COVID-19 and what it means to parent and to teach this coming school year. And we certainly don't want to, push forward, with the legislation without having that context be recognized. I mean, we're really asking a lot from parents to, if we go forward with things like a staggered schedule and with distance learning, parents are going to face a lot more burden in terms of helping to teach their kids at home as well as supervise them outside of the school campus. And in fact, what's kind of strange is that this coming year, if one of the proposals is to have only 1/3 of the school population on campus at any one time. And if that's the case, those situations which are hard to supervise on campus, might be mitigated this school year because of the fact there'll be lower school and there are lower numbers at the school at any one time. So it is kind of a strange year. We wanted to make sure that we didn't just put forth our position, without having to taking those issues into consideration, and then having an open conversation with representatives from our parent teacher organizations. So we will have that scheduled on Thursday at 3 p.m. Like with most of our meetings, we will also stream it live on Facebook. So those parents who want to come back to it and later on can also listen in on the discussion. So if you allow us, after that, we would be happy to update our testimony and provide you with the results of that discussion.
Thank you very much, Superintendent. You'd be very happy to allow the extra time, yes, for the testimony. And I'm glad you explained that the circumstances, and I realize you're preparing for the school year, but I didn't realize that we might have a twist in this whole scenario that at the schools, at least at the schools. So
right, I would say to the parents, you got more to do, plus you have a penalty for things that it just has to be put in context. And we're in the midst of explaining those issues to our parents about the new school year, and we'll also take the opportunity to explain that this is another matter for their input as well.
I appreciate that. I'd like to recognize Senator Sabina Perez. Thank you for joining us, the Vice Chair of our committee. And also, it looks like the Executive Director, the Public Defender, Attorney Stephen Hattori, has also joined us. Thank you for joining us, Steve. We will now allow testimony from the Public Defender's Office, or Attorney Morrison, did you want to proceed?
Senator, thank you very much. Mr. Hattori was going to speak on these two bills, but since he's just joining us, I don't mind getting started, and that way he can pick up where I left off if he sees fit.
John, you want I have my testimony prepared. I apologize. I just got out of court with Judge Sokola.
You may proceed then, Attorney Hattori.
I'm sorry, but this is on the two parent accountability bills?
Yes, we heard from the Public Defender on the first bill that was introduced by the governor, but we just decided to open it up to both because there was testimony on both bills at the same time. So the Vice Speaker introduced her bill, and we are now hearing testimony on that bill also.
Okay, so, great. So could I proceed?
Yes, please.
Thank you, Chair. Dear Chairperson Terlaje, members of the committee, the Public Defender Service Corporation appreciates the opportunity to present testimony on Bill number 31035, the Parent Accountability Act of 2020. It's an act to add a new Chapter 93 to Title 9, Guam Code annotated, relative to holding parents accountable for the harmful action of their children, which is sponsored by Senators Nelson and Senator Shelton. Now, the proposed legislation intends to create a civil and criminal cause of action against the parents for destruction of evidence, destruction of property, and other willful or malicious acts. We just wanted to point out that there is existing Guam law on that. I'm sure Mr. Morrison brought it out earlier. So we have two different provisions. One is under 18 GCA Section 90-113, which creates civil liability for parents in actions involving destruction or damage to property, as well as personal injury. And this was enacted in Public Law 33-126, and that's 18 GCA Section 90-113. So that's one provision. There's another area of law that creates parental liability regarding graffiti, and that's in 18 GCA Section 90-113B as well. And then we also wanted to point out a different provision regarding 19 GCA Section 5117, and that one specifically is titled Jurisdiction Over Adults, and this imposes criminal misdemeanor liability on a parent or guardian, or actually any adult who acts or fails to act in regards to a child that causes or encourages a child to become in need of supervision of family division of Superior Court. So basically, if an adult or any a parent or guardian is with a child and they see the child committing a crime and they fail to stop the commission of that crime, then they're usually charged with jurisdiction over adults. And I know we've seen this charge time and time over the years. And so it applies basically for it's broader than the parental liability statute that's being proposed because it also applies to any adult, not just parents. It could include uncles, aunties. So you'll be in trouble for your nephew's misconduct if they do it in front of you, or if you encourage it. So there is existing Guam law. The other problem that we have with this bill, and I'll submit a more thorough written statement, is that the definitions involved are a little vague in terms of like what is like for example, a bystander. It's defined as a person who looks on but has nothing to do with the activity that is in progress. And then later on it says references how a bystander must that initiates and or incites the continuance of the offense. So it seems like the definition of bystanders might need to be clarified. But of course, the law currently exists to prosecute this person with a misdemeanor offense under a separate statute, that 19 GCA section 5117. And so that is a charge that currently exists and has been charged down. Okay. There's also an issue of, the parents are consistently being held liable for their children's damage or injuries in our juvenile matters. So parents are being held accountable. In fact, I don't know if you're aware, like Judge Barcina, sometimes he'll have the parents, when he was in charge of juvenile court, they would actually have to perform community service like from 8 to 5. And so that's a pretty great incentive that the court imposes to ensure that parents keep better, track of their children. Okay, but we don't have anything else to add. John, did you have anything to add on this?
The only thing I guess I wanted to add is that since these family court matters are confidential for the good of the child, it's unfortunate, the paper and the community members don't get to see the successes of that court. They don't get to see the failings of that court. And like Director Vittori was referencing, we have had judges get very creative in this process, require that they shadow their children at school, which I would imagine is quite embarrassing for the child, as an incentive not to get in any more trouble at school. So unfortunately, the community doesn't get to see those things, but it really is for the benefit of the parties concerned in the proceedings.
Thank you to both of you from the Public Defender's Office for your testimony today. And I'm going to open it up to the panel. I hope there's, I'm sorry I did that spur of the moment to combine both bills together, but I hope it's not that confusing for everyone here. It's a little confusing for myself, but the bills seem quite distinct. One is imposing a criminal penalty, and the bill by the Vice Speaker is affecting civil liability for parents for different types of action, if that's correct. Vice Speaker, would you like to begin with the questions or comments?
Yes, thank you. And thank you, Stephen and Attorney Morrison for your input. Stephen, you mentioned that there were other areas in law where parental accountability exists. However, what we're trying to do here is create an act where it's very clear that that these actions will be able to, that the actions made by the child, that the parent will be responsible, but to include that these penalties and these fines may be waived for good cause if the parent engages with the child more. So that's really the intent. It's not just to throw out specific fines and, just totally or completely have such a harsh consequence. It's really trying to engage more of a a holistic approach to the child and address the child's needs. And so really, as we moved forward with the bills, we constantly mentioned that we wanted to promote family counseling and look for avenues to for the parent to become more engaged in the child's life. And in many cases within the Guam Department of Education system, we have students that create or causes these certain actions of rioting, or and we've seen videos of children beating up on, just jumping a singular kid, and there are other encourage this kind of violence, this type of bullying. And so what we're trying to do is really direct that towards the system at Guam Department of Education and require parents to be present in family counseling matters, in anger management matters. And you did mention that the judge, Barcinas, requires the parents to be present for student shadowing, and so does DOE, but many times the parents don't even show up. When the students are causing a fight or being violently or abusively disruptive in class, the parents don't show up. And so really, we're trying to bridge this gap. So instead of just handing out fines and penalties, what we're trying to do is bridge the gap to make the parents be more accountable. In New Zealand, they have within their court system, a juvenile court system, but the judge brings the situation out to the community. And so the child who has done like an egregious offense, they're not tried in a courtroom. They are brought in like a counseling center, in a church area, or in one of their sacred homes, because that's part of their New Zealand culture. And so really, we're trying to find that midway, where we can help these children and bring them up, rather, and encourage the interaction of the parent and encourage the interaction of the community, not just to put out fines and penalties. And so if there's a way that you could help us make this bill better to that end, then that would be great, to provide that kind of solution. And so really, it's something that we discovered in New Zealand that has helped a lot of the youth, especially those, because the issue here, there's a lot of, and according to the statistics in the count, they also do it in the Guam Department of Education Student Services Support Division, end of year district student conduct report, academic period, August 17, 2017 to April 30th, 2018. They also do the breakdown of offenses by ethnicity. And so a majority, the first one in the ethnicity piece to create the most offenses are the Chamorros. And then the second listing are the Chukis. And so really, we want to find a way how we can help the children deal with their cultural identity, because we understand the impact of certain types of assimilation when you come to Guam. They're not familiar with Guam laws or, the way the city life of Guam, the of island living is what they've known and what they were raised upon. And so really that's the end goal of this legislation. So,
if I could.
Yes.
If I could say, this legislation is really well-intentioned, and it's probably better than the status quo statute, because it does provide, the parent with ways of escaping, criminal liability. So, we'd love to work with your office on developing other ways of whether it could be diverted or, where it doesn't result in a criminal conviction, but it still accomplishes the purposes of the legislation. It's really well intentioned, and it's far more detailed and more, I would say, holistic than the current statutory provisions, which really just hold them criminally responsible, but it doesn't really provide an avenue for any relief for the parent. So this one is actually it does engage the parents and it gives them incentives to, rectify the situation. So I mean, it is a better approach than the current law.
Thank you, Mr. Hattori. And that's what we'd like to do. We'd like to provide the avenue for the children, to receive the services and the help and support. And in many cases, we're coming up to the budget season, and I've just noticed that in my short time here, we always budget status quo. We give enough money for the agencies to stay in operation, to make sure everyone gets their salary, and to perhaps move forward with a little program if the money does allow, if the budget allows. However, I feel that in the way we've been administering our budget appropriations is we're not focusing on the core issues of our island. And for one of the core issues is child welfare. And so, I'm hoping that, in the future, we can bridge this gap where we can start focusing on some of the core issues on our island and how we can craft our budget really to address all the issues in that specific area. And we can move forward with concrete programs rather than just the continuing of funding agency status quo and moving forward with that, but really the people knowing that these agencies are focusing on this matter. And that's really what we're trying to do with the Apparent Accountability Act. It's just a small bite, to try to get us there, where we're talking about social welfare in a broader area. And so I understand that there are other statutes that exist, but we're really just trying to find this gap where we can encourage the parents to be more present, allow the community to interact more, just like I was raised. It took a community, a village to really raise me. And so and because of the impacts of technology and social media, the children are lacking that interaction with their parents and their elders. And so I'm hoping that we can fix this measure to do just that. And so I'll be calling you soon, okay? Thank you very much.
Thank you.
Thank you, Madam Chair.
You're welcome. Any other senators who would like to ask a question? Senator Lee.
Thank you very much, Madam Chair. I just wanted to, I missed the beginning part of the public defender's testimony. So I think it's Attorney Morrison. If you could just maybe just generally from the public defender, both you and Attorney Hattori, if the proposed punishments in both the governor's bill and in the vice speaker's bill, if those, in your general estimation, if those proposed punishments fit these crimes.
Senator, I began speaking about the governor's bill, and what I'd indicated in that was that it seems to criminalize inaction, that these parents in overwhelming large part have good intentions, and I'm not sure what they're supposed to do if short of putting their child up for adoption, if they're repeatedly causing the parent to be a criminal. I just think it's a slippery slope with the governor's bill. I have less concerns about the vice speaker's bill. I think it's well intentioned, and we have a team of juvenile attorneys in our office that are experts in this field, and we would be happy to engage further in a conversation with her staff. That's largely where I started and finished with the governor's bill.
Okay, thank you very much. And I did catch the section of your testimony where you were expressing that you were concerned about potential misapplication of this law. And so I think that's helpful for the committee to hear. And hopefully we'll be able to move forward with one iteration of the bill and just be able to also receive testimony. And I want to thank Ms. Borja and the superintendent for being here. And I agree. I think we need to extend a little bit more time to give our community and our stakeholders an opportunity to provide testimony on this bill, because I do think it's, there's some merit there. We just need to figure out how best to move forward. And it's really a lot easier on us when we have the input from our stakeholders. So thank you very much, Madam Chair, and thank you all for participating this afternoon. This is just Masi.
Thank you, Senator. Senator Taitukwi, you're recognized.
Situ Masi, Madam Chair. Thank you, everybody, for being here. Superintendent Ms. Borja, good to see you, as well again, Mr. Morrison, and thank you, Stefan, for being here as well. When I was researching the bill 277, I did come across the Guam Code Annotated Chapter 19 or 19, Article 5. And I didn't realize on top of that, there was other ones. I believe you mentioned earlier that it was Guam Code, I think it's 18, Section 901. And then you have another one on Guam Code Annotated Chapter 19, 5117. So there's several different areas in here, but I was actually just focusing on A, B, and C, D, E of 18 GCA 90113. And I think, Ms. Borja, when you do meet with the other parents regards this, those particular bills are very important to look at, especially with the one that was announced earlier, currently 18 GCA 90113. It actually has an amount up to $25,000. The liability with regards to anything medical or property or damages, hospital expenses, etc., at $25,000 versus the other two bills a little bit less, one at $2,500 as well. But that also includes a felony, which Guam Code Annotated 18, Chapter 18 does not have a felony involved in that one. But so. Yeah, I didn't realize there were other laws that pertain to this, but I appreciate too, Mr. Morrison, what you said about not being able to hear what happens when judge makes these rulings on cases like this involving parents. And it's very helpful. I think if you can provide some kind of information to us about what really happens in the courtroom, situations like this happen, and what do the judge usually rule in those circumstances, it would be helpful to see what they're doing currently now and what's helping. So that's just my comments, Madam Chair. As said, the concern I have was the fact that the law does already cover the responsibility of parents in the law. And I appreciate the opportunity. And again, Ms. Borja, thank you for being here. I know you're very busy, but those laws are going to be very helpful when you go to meet with the other parents and share what's already currently in the law now. It'll be helpful. Okay, thank you again, Madam Chair, for the opportunity.
Thank you, Senator. Senator Luis Muñoz.
Thank you, Madam Chair. So I guess my first question could be for maybe the Public Defender's Office, either Attorney Hattori or Attorney Morrison. So if, would Public Defender be more in support of Bill 277 if the liability was reduced to maybe a violation rather than, rather than a misdemeanor?
Senator, from my perspective, I mean, that would certainly be a step in the right direction. I wouldn't say that completely, solves any issue that I see with it. But of course, I mean, I think the upshot here is that we don't want to have parents that are well-intentioned and are just having a difficult job raising their children who become criminals and are suffering real criminal penalties as a result. Certainly, if it were a violation, I'd be less concerned about it, but I think there's probably something more holistic that can be done as far as what we order the parents to do once there's a finding of delinquency.
Okay, thank you for that. It helps to understand also like what's currently in law. So one of my other questions was, you mentioned, Attorney Hattori mentioned Section 90113. So if you can maybe help me understand what would be the difference between that section and Bill 310? Do you see a difference between the two?
90. What? So 90113 doesn't really have any, doesn't contain any defenses like would exist in the bill being proposed. So the current bill has some certain defenses built into it, how parents can get their liability waived if they can demonstrate certain things. Like there's a provision about court waiving all or part of liability if they can show good cause, but all this happens in the juvenile court, and so these cases kind of presume that it will result in there is a juvenile prosecution. I know that the AG's office has a lot of cases that are being resolved without even being charged, and so they have a very good program worked out where it's almost like an Alpha Malik type program where the victims and the perpetrators, either they work something out without any charges ever being filed. So I think this one, the proposed bill provides protections to the parents, although it's still a misdemeanor though. And but the way that it would be resolved in practical terms, I mean, I don't really see the AGs wanting to tarnish someone's record with a criminal conviction for something like this, as long as they comply with all the conditions that the court imposes, like parenting class or other things. But it is capable of being applied that way. I just think that currently the AG's office has been pretty responsible about not flexing their muscles unfairly. And so but the statute itself doesn't really provide it. It's something that would probably be worked out between the attorney generals in our office.
Okay, thank you. Thank you so much for your comments. And of course, understanding where the public defender stands in these types, you see these cases more often than we do. So you can help us understand how to navigate through these positions, because as a parent myself too, I have to balance as well that there could be some opportunities for my child to do something without me knowing, and then me becoming liable for that. And then, so I understand the balance between the two has to be found, whether it be 4277 or 310. Some of the things that I kind of I'm thinking in my head is like, what is the possibility, maybe this could be for Ms. Borja, of parents who have, like, say for example, uncontrollable kids. What is the possibility of them just kind of washing their hands and declare their children just beyond control? Is that a possibility too as well?
I'm gonna have to ask the superintendent to kind of give him some input on that question.
I think the approach we're trying to take is, I think I would agree that we're not trying to necessarily criminalize parents. We don't want to make it more complicated for kids to get the care that they need and the guidance supervision. But on the other hand, we're well aware of situations where a lack of supervision contributes to the situations that go on in the village and into the school. And we're really talking about a small group of kids. We're not talking about a widespread, number of children. I think and again, I know I want to just say this, Vice Speaker Nelson, she's requested updated information. We will provide that as we provide the updated input. But you're talking about maybe about 250 or less students who have the multiple serious incidences in our schools who end up being in this category. And this is out of a school population or district population of 29 to 30,000 students. So we're not talking about trying to do mass criminalization of parents and knowing that that's a difficult job. But we do want to, maybe the word on the legal side is create some type of rebuttable presumption that there is a responsibility, a duty that needs to be set forth, that has to be met. And then yes, allow for these, for parents to rebut that presumption or find some type of agreeable solution that does end up addressing the needs of the families that are involved. So we're not really, that's why I think it's a very nuanced type of discussion, but there has to be some type of incentive to reach that type of a resolution. We run into situations, for instance, just in the last year when we ran into situations with families and the kids who were involved in these very violent activities at school. And it's hard. We try to reach the parents. Parents are not able to be contacted for one reason or another. They end up showing up after the police have taken the kids away from school, and by that time it's out of our hands, and we end up dealing with the parents only at the end of the process, meaning after they've been apprehended by the cops or after they've been expelled and they're seeking some type of relief. We're trying to find a way to ensure that for those kids in those difficult situations, we can have a way to bring those parents in before it's too late. And I guess that's the balancing act we're trying to achieve. So I think for us, as we gather input, that's the type of discussion we anticipate to have, not whether or not a year or this fine is strong enough, but we're really going to be talking about is this enough incentive to begin putting some of that responsibility back on the parents to find, work with the courts, work with the schools to find that the right situation. And when it comes to the family court as well, I know the attorneys know, even the schools don't always know what happened, as a resolution to these matters. So even in that sense, sometimes, the courts may be doing a good job trying to find that balance, but it may not translate to the schools, and the schools don't know what exactly happened in those situations. And without that knowledge and working together, sometimes those issues reoccur. And so, there's a lot of things here that we need to kind of resolve as part of the solution.
I think it should boil down to the communication from the parent dealing with the court towards the education system as well too, and how, like you said, it's difficult to try to find that balance to hold, give them an opportunity to be more involved in their children's education. Madam Chair, I don't have any more questions, but I am looking forward to the meeting that the board and the parents are going to have, and see what the testimony you submit to the committee. Thank you so much for being here. Thank you again.
Thank you, Senator. We'll now go to Senator Sabina Perez.
Thank you, Madam Chair. So yes, I do appreciate the holistic approach. I myself, being a former teacher, I know I've seen the struggles that our students face. I see, cultural displacement is one of the factors. Drugs is another factor. And I just want to have a question, perhaps for Superintendent John Fernandez or Carla Borja. Do they see changes happening in regards to the riots themselves? Has the cause changed through time, or is it pretty much similar? I think it's very important to kind of understand the roots of these problems in order to address them properly. Has there been a study to determine that? And also a second part question would be for Attorney Morrison is, can you share some of the success stories and how to basically prevent recidivism for these students?
I can try to answer the first part of that question, which is, you're asking more for kind of an overview as to why the riots occur and what's happening over time. So, but I don't have the answer to that. I can say that it is very clear that whenever there is an issue on campus, it's always important to investigate and find out the specific causes of that incident, because so many times it's easier to just generalize that there is some common type of situation. So if we look back over the past year, you'll recognize that, you know, in one incident there will be ethnic or racial issues, and that come up between for instance, our Chukis kids and our Chamorro kids. In other incidents, you'll find that it's a family issue that started in the community and made its way into the schools because it wasn't handled or resolved at the community level. And so you have a range of the different issues. So for us, as we try to resolve those matters, it is about trying, for instance, it's about going to those families and trying to ensure that we try to resolve or put away these issues that are leading to these fights. So if there is a disagreement about about a relationship or about two groups of people trying to retaliate, a lot of that is just case by case types of situations. I think the one thing that I would point out is, and I don't know if you've seen this, and I know Vice Speaker Nelson, those of you who have been in the school setting, we seem to, in the past few years, we've seemed to have these issues come up at the beginning of the school year as the kids are coming back from the summer. They're reorienting themselves. They may be positioning themselves at certain benches, and others say, "Hey, that's our place." And you just have this clashing going on. And this year we did see that kind of major outbreak of these fights that happened early in the year, but have since calmed down. As part of that, though, we did, as it was not the outcome I desired, but we did ask that the principals draw a line when it comes down to violence, and we tried to leverage expulsion as one of the tools, but that's not something that is sustainable as a tool to expel our kids, because at the end of the day, we want them back. We want them learning, and Vice Speaker Nelson has been, on my case to make sure that we don't lose these kids simply because we need them out of the campus for that violent response. So I don't have a study and trend, and that's something we can focus on if there are things that we can identify. But a lot of it is just case by case, school by school. Is it happening because of a girl or a guy or a family, or is it just somebody looking at somebody else the wrong way and all of a sudden they get into a fight? So those are the things that are hard. I do worry very much about the disproportionate impact that we see in the statistics relative to our Chukis children. And I think you're well aware of what that looks like. In our latest information, and again, we'll provide an update of that information, of the total enrollment of Chuki students, about 65% of them are disciplined, compared to, I believe, 25% of students who are disciplined, are Chamorro students. So there's a higher rate of discipline. And of that 65%, about half of those kids are getting suspensions, which are a more serious consequence. So, as we talk about the statistics overall, we're talking about a small group of children overall, students overall, who are getting involved in these serious offenses. But when you look at it on an ethnic standpoint, we do have an issue here on Guam, and we have to figure out how to deal with that. And that's, I don't know if there's, I'm sure they're seeing it in the courts because they're seeing it at DYA, they're seeing it at Department of Corrections as they get to be adults. And that's really one of the issues we have to face up to and try to resolve. Because if we do resolve that, that is a big chunk of some of the incidents that we're seeing at school.
The second part, I'm sorry, Senator. I think the second part was for me, and I'd be happy to give some examples. I mean, I understand the audience, and to consider something a success myself here, I think would want to say that somebody got in trouble one time, the process scared the life out of them, and then they never got in trouble again. And I think those are the vast majority of these cases that we see that are charged out as juvenile delinquency cases. I can think of a number of cases over the years where one 14-year-old girl is bullying another 14-year-old girl on Twitter and making threats against her, and she gets in trouble and sent to court, and the two parties work it out, and they go to an ophthalmic together, and at the end of it, the bullying stops and a new perspective's gained. And I think that's what we all want. And those sorts of things are the overwhelming majority of cases. And you know, the judges and the people that work through those cases never get any credit because it's not public, and that's by design. But I would say there are additional successes that we have, and those are in a lot of the judges' orders. Those are things like when parents are ordered to go to parenting classes and it makes an impact on them. When children are ordered to go to services and it makes an impact on them. When the judge orders a parent to shadow the child and that has an impact on the child, and that actually works periodically. I think those are great successes. We also have person in need of services cases, which are similarly sealed to the public. And I think if you really want to watch resources be invested into a problem, those are the hearings that we're lucky enough to be able to go to as practitioners. And you see just all the services on the island wrap around the child and the parents and try to put the child in a better position. We also have the Guam Family Recovery Act that seeks to do some of the same work, but with an eye toward rehabilitating the entire family. So these things happen at court every day. And on one hand, it's perfect that the community doesn't get to see it because exposing the child in that fashion may have consequences. But I think it's important that the stakeholders and senators are aware of it.
Right. Thank you so much. Thank you, Madam Chair.
Thank you, Senator. Senator Marsh-Titano.
Seduce Mahasi, Madam Chair. You know, I'm really glad that I got to be here this afternoon and hear the discussion. Probably all of us have family that we're really concerned about, and of course the rest of the community along with it. You know, I think quite often of my granddaughter when she goes to the bus stop and it's dark outside and there's a bunch from the neighborhood just there together, and I really worry about them. As do we all, right, about what's happening with our youth and in our schools. And so I think we've had some really good discussion here, and I really appreciate with these bills the intent of them and that it's causing this discussion, and we're going to hopefully go in a good direction with them. It really meant a lot to hear that the public defender sees that they provide some nuances and some clarity that might not be present in our current law. And so that there is very good potential for them to do good if they go through. And that the public defender's office can help direct the legislation so that it continues to build on itself and really do what the Vice Speaker and the legislative secretary were thinking about when they wrote this, right, is to help the parents and families and direct them towards perhaps systems that can help resolve the situation, because what we really want here is change of behavior. A lot of times, maybe our natural reaction is the punishment and so forth, but if we really want the change of the behavior and the change towards more safety for our children, then we have to think about what works. And I remember throughout this last couple of years, you know, we have heard from the judiciary and others, and they've talked about the success of therapeutic courts, that we continue to go in those directions, and that those kind of actions seem to make the real difference that we want. And also what comes up is, in looking at this, you know, gosh, I remember all the way back to the years of getting my bachelor's degree at the University of Guam, and we had these discussions about nature versus nurture. And so this is part of what makes me really hesitant when we start getting into the areas of criminalizing things, right? Are there biological reasons that the child is acting a particular way and the parent can or cannot actively mitigate that? And even for the family themselves, maybe the parent has some biological reasons which make it harder for them to to provide perhaps the structure that's needed. We have a lot of families that are struggling, and so maybe they're working 2 or 3 jobs and they haven't been able to be there, or they themselves were raised in a home that didn't provide that structure. So there are a lot of situations, and I like that Bill 310 provides, or will provide once they continue to build on it, that understanding that there may be these situations that we need to try to step in for, but it doesn't have to be criminalization. It can be that positive support, as Ms. Borja, if she's still here, Ms. Borja was talking about. And so I really like those aspects, that we have opportunity for education, therapy, family counseling, anger management, sweat equity through community service. The shadowing the student, I thought that was pretty creative. I've done a variety of things myself as a parent to try to have those creative solutions to try to get the kid back on board. But I think this bill has the potential to tackle both those questions about, is it nature, is it nurturing, and what can we do to help change the behavior? Because we need to find out if the child is in one way or another a victim, or even the parents themselves of something, right? So one of the questions that I have is, what other crimes do we fine $1,000 for? And is that penalty within this bill on par? Or are there any recommendations?
That would be any misdemeanor.
Yeah, so for misdemeanors, the cap is 1,000. So anything that's a misdemeanor, it's the cap. But usually it's less than that for certain types of crimes, like criminal mischief might be a $250 or $500 fine. So it all varies, but the maximum is $1,000. And ordinarily in these types of cases, there's restitution involved. So judges often do not impose a fine if the parents are going to be paying restitution for their children.
This Masi, Pera, and now that's helpful to know, because of course we want it to make sense within the larger picture. And if I could ask the GDOE superintendent to also help us understand some of the programs that are there. I know that there's been an anti-bullying program. Are there programs there for promoting acceptance of diversity, or I know that there are counselors, but I'm not sure their ability to provide the level of support that you're seeing that your students need. Do we need more counselors? What are some of your thoughts on those issues?
Well, I guess what I would say is that when it comes to the bills that are being introduced, at least my understanding is that they were being introduced in part out of a response for some of the most severe issues that were coming at that were happening in school, including mostly violence, violent activities at the school level. And so if we take that and if we keep that focus on those types of incidents, what you're really talking about is a smaller group of students who will need a more focused set of strategies. So, because we could talk about our positive behavior framework and how, we are organized to, create positive incentives for kids to choose the right kinds of conduct, but we're not talking about the vast majority. We're talking about those cases where kids are making the wrong decisions that are having highly disruptive, harmful, impacts on other students and leading to an unsafe environment. And in those situations, again, that's why we're talking about more, I guess, extreme types of strategies where you're going to have a multi-agency approach to it, whether it's the courts, whether it's behavioral health, DOE, and other agencies. So we do and have launched our own school-based psychological services as part of our partnership with behavioral health, but doing it from the school-based side so we can more immediately respond to those students who may be acting out due to some type of psychological issue. So we are looking at ways to do a better job assessing and intervening and treating and diagnosing, and then partnering with our, with the partners for referrals to more specialized services as needed. And we can continue to provide that. But we really are talking about, a much smaller group where, they're more at risk, due to some of the situations that our public defender and other senators have raised. There may be broader dysfunctions in the community and the families that are having an impact. And again, we're not trying to, it's not necessarily about trying to criminalize, the parents. It is about trying to find a way to incentivize the level of intervention needed so that the violence doesn't happen at school or these acts don't take place the way they are. And again, so that's kind of our approach. And yes, there are many ways in which we try to promote positive behavior, acceptance of diversity, fighting drugs and alcohol abuse. But for the most part, what I think we're talking about here is really very small population that we need to do a better job doing more to get the right results. And again, some of it may be on the side of stiffening penalties, and the others about increasing therapy, and somewhere in the middle. But it's going to be a special group with more focused and intense services, is my guess. So that's what I think. Yes, it's not the vast majority of the population that we're seeing this need. It is, like, again, I said about 200, less than 250 students who kind of fall into this category of multiple severe disciplinary issues at school, and we need to find a way to catch them before it's too late.
I agree. Trying to catch them before it's too late. I mean, it does a service to everybody. It does a service to them, and then the rest of the community who live with them for the rest of their lives.
And if I could add to that, Senator, the only thing I would add to that is that I think the reason why you saw our testimony last October and our call for other types of strategies is because I think our employees at the school setting feel that that the burden is on their shoulders, on the administrator's shoulders, on the teacher's shoulders, on the counselor's shoulders to find the solution all by themselves. And that's where the frustration builds. And we hear from them, like, how are we supposed to deal with this? We don't have the expertise. We don't know what's going on at home. We're not, we need to work with other people who have that expertise. And I think that's where this frustration and this call for more accountability from the other players has really come from.
I agree with that, and I'm glad that you brought that up. It's important for us to hear that. And I liked what you said about a multi-agency approach, because we have those experts. And although we understand that they're stretched into, there has to be a solution, like we have to figure this out. And that's why part of what I was asking was, is there an area that we can be supporting you better in? And I don't know if there's a council within the school systems that sits down and hashes this out or not. I'm not sure. But my other question is to the chairwoman. I'm hoping that, or the author of the bill, I'm not sure which way it goes, but I'm hoping that we can hear from some testimony, and maybe there were some queries put out there, but some testimony from the courts and the judges who also see these cases go through, and maybe from the Guam Behavioral Health and Wellness Center as well. Yeah, I mean, I really applaud the authors of the Bill 310 and the governor's bill, as well, as far as making sure that we have this conversation and trying to get us somewhere where we're tackling these issues. And so, Sujus Maasi, Madam Chair, for letting me ask those questions.
Thank you very much, Senator. Senator Moylan, you're recognized.
Thank you, Madam Chair. Thank you, Madam Chair. I have no questions. I do appreciate the input. It's very helpful. And I thank those that came to testify. I appreciate your time and your information. Thank you, Madam Chair.
Thanks. I'd like to follow up with a couple questions of my own, if I may. First, I want to note for the record that the fiscal impact, according to BBMR, is dependent on the extent to which the proposed creation of a new crime translate into increased caseloads and responsibilities for the Office of the Attorney General. Per the Attorney General's office, this will mean additional personnel may be required to take on additional caseloads. That's for the governor's bill that makes it a criminal penalty. Due to unknown variables regarding the number of caseloads that may arise, a bureau was unable to determine the amount of personnel needed to handle such caseloads. They also noted that the $2,500 fine proposed in the governor's bill does not specify where such funds would be deposited. And they further said that the Department of Corrections may experience a new category of criminals being housed in their facilities should the prosecution result in a term of imprisonment as proposed in the bill. BBMR was unable to quantify both the anticipated revenues in the form of fines or the potential amount of additional prisoners due to punishments being dependent on the prosecution of the individuals. The fiscal impact note for the second bill cited the comments on the first bill, Bill 277, and said it was pending feedback from the Attorney General's office. But I will note, it's my own observation that the second bill does not impose criminal penalties, so I don't think it should impact the Attorney General's office as described in the first bill. All right, so my questions just have to do with, if I could just separate them a little bit, so the current family court process, under that process, the courts are authorized to bring in the parents and to impose counseling on all the parties. Is that correct? Under the current system, if a person commits a crime, a juvenile, or let's say a minor commits a crime, are the courts able to bring their parents in also, and are they allowed to force counseling on the parents as well? I guess if Mr. Morrison, if you have any idea.
Senator, certainly the parents are expected to participate in the process, and typically both parents are requested to come in if that's the family dynamic. And relative to ordering counseling, I've certainly seen it done. Mr. Director Hattori, do you have anything more on that?
No, yeah, I totally agree with you. The courts do routinely order the parents to attend, and if certain times they actually issue pickup orders for the parents if they are totally not cooperative. So if they receive a summons to appear for a court hearing and they don't show, then they often do get bench warrants, and that usually gets their attention. And so in certain PINS cases, if a parent doesn't undergo the drug treatment program they're supposed to, then they do serve sanctions and they're held in contempt. So the court does have a lot of power to enforce their orders.
All right.
I would try to separate things a little bit between the juvenile delinquency cases and the person in need of services cases. The parents are an actual respondent in the person in need of services cases, and orders can be made to bring the family back in conformity. The judges, under both set of circumstances, though, enjoy the power of issuing citations for contempt. If they order something and it's not done, they can issue appropriate orders for contempt.
All right, if I could distinguish, we're talking about person in need of services, meaning there's been some kind of neglect or harm to the child, and the child is in need of services, right? So
something occurred that is going to result in jurisdiction in the family court. So it can be neglect, it can be abuse, it can be a variety of things that are going to result in that. Sometimes a case begins in juvenile delinquency court, and after further examination, the judge realizes that it's something that better belongs in the as a PINS case and requests that it be refiled as such because the problems are going to be require more help to fix than initially sought.
Okay, and it's my reading that these bills are not really kind of geared to get involved in those cases, that the court is handling those cases as to, what a child might need from its parents, from anyone else, that the court's going to take care of that. But as to, like, for example, the first bill 277 talks about when a minor child commits a felony or misdemeanor, and you described those as the juvenile delinquency cases. Is that correct? That's how they're treated?
That's right. Well, unless the case by virtue of statute can be charged out in a court if the child's reached a certain age and the crimes are sufficient. Yes, typically, yes.
Okay, so I'm assuming that we're talking about cases that are charged out as juvenile delinquency cases. The minor is the one who has committed a felony or a misdemeanor. And what kind of liability are we going to put on the parents for this child? So this first bill says that it will be a violation for a parent to permit or encourage their minor child to commit this felony or misdemeanor. And that's when the fine comes in, all right? So if they find that, if the court finds, this is, they're going to put this into the statute on Title 19, which is the parent and child relationship, but it just sounds like a criminal proceedings to me. And I wanted to know from you, what, if this was enacted, what do you anticipate? Will parents be then represented or appointed attorneys to, because they're also being charged with the crime in addition to their children?
So it's a misdemeanor offense punishable by a $1,000 fine and potentially a year incarceration. So yes, they'll be entitled to counsel.
All right, and but right now, if a child commits a crime, the courts can order parents to do different things, but not to be put in prison and not to, what about a fine? But they can currently be fined only if there's damage, or can they be fined independently of the fine placed on the child?
There's no mechanism to currently give the parent a fine. I don't believe we have a statute that addresses that particular issue. No. There are some courts that agree that the parent can be held liable for restitution. There are some courts that agree the parent can be liable for the payment of the expenses associated with staying in DYA if that's where the child is housed.
Okay, and then we talked about the existing law, which was 18 GCA 90113, talking about liability for, it says for misconduct of the minor, but it's civil damages. It's talking about civil liability for harm, for torts, for harm, medical, dental, hospital expenses, other damages that we would find in a tort action, such as I'm sure property damage and bodily injury damage, like expenses. But so have you seen this statute been in action, I guess, or have you seen it where this one seems to me, we're talking more about the victims. So for victims, if a minor has harmed your property or your body and you have expenses, that you can seek reimbursement of those from the parents under this statute. But defacement of property, and I guess for graffiti, as you talked about in the other statute also, but I don't know, I'm just trying to see if this statute that exists in law has any effect on behavior of the child versus
So, Madam Chair, so this particular statute, I think it would result, someone would have to civilly sue, and this would be the basis for a civil lawsuit, but it's not something that would happen in one of the a pending juvenile proceeding. So unfortunately, the victim would have to get a lawyer and use this to sue them civilly.
Okay, right. That's one thing. It's like a victim-oriented statute that is for victim. If they need to get something, they're going to go through this. But it's my understanding these bills, we're trying to curb this behavior in these minors, and I'm just trying to, I guess I'm going to ask again, yeah, how do we get to that through this bill? So the theory must be in the first bill that to stop minors from committing felonies or misdemeanors, we're going to threaten the parents that they're going to be punished if their children do that. And I guess has any of you have seen any success with these types of statutes in curbing the behavior of the minor, the bad behavior?
Madam Chair, just what bill are you talking about?
I'm talking about 277 right now, the governor's bill. Thank you.
So
it's imposing. Yeah, go ahead.
So this one, it would actually be handled in the adult criminal world, and it's not as let's say therapeutic as the family court division. And so when a case is filed against a juvenile in the family court division, the judges have an incredible amount of discretion, and they do exercise it, and they do order things like family counseling and different treatment that is usually not ordered in a typical adult case. Though most adult cases, if it's not related to drugs or alcohol, will just result in payment of a small fine, some community service, and maybe in this case a parenting class. But the family court really is far more effective at controlling the behavior of children than this one. This one would just really it really takes the kid out of the equation and just place it solely within the parents.
That's what I'm wondering. If we put the parent kind of on the defensive as a criminal defendant at this point, I'm even wondering if that severs any possibility that the family court is able to, bring those parents in to work with the child with counseling or anything else, because now they're criminal defendants as well. And I don't know if that would interfere. But do you have any comment on that part, or otherwise I'll move on. Superintendent, have you seen any threat of criminal liability for parents to curb a child's behavior?
I haven't seen any. I mean, I haven't seen any results. I couldn't speak to that. All I know is that I think the cry for more accountability is really coming from the fact that in many of these cases, it's really hard to engage with the parents until, like I said, after things have already happened, and kids are being expelled or punished. And so we're really, for that reason, I think our stakeholders are looking for ways to get them involved prior. And if the fear of some negative penalty is sufficient to do that, it's not really trying to get them criminalized, but trying to ensure they have an incentive to engage before they ever get to that point. But I haven't seen any statistics on that.
There's the word, incentive. Thank you. I think that's what the family courts wield right now, some kind of incentive for dealing with it in family court, everyone, and not having criminal liability. Okay. So if I can move to the Bill 310, just some specifics on this. I want to thank you for your testimony on it, and pointing out the highlights of it are that it really continues to give the court flexibility, and especially the part that allows the court to waive liability for damages and for different reasons. And again, I think it incentivizes parents cooperating, right, with the courts, the family courts, especially to do whatever they've found to be successful with the children. does, so we've heard that the DOE has it can order, or not order, but encourage its own counseling at the schools, kind of a deterrent, right, prior to getting involved in the court system. And then if a child is involved in the court system, the courts have the ability to order counseling and other things that they found to be effective. And I know that they continue to try different things as these are proven across the nation. But I guess I just wanted to ask then if there is anything in the current family court system, I guess, that you feel is a deterrent to stopping or prohibiting, or is a deterrent from getting minors to stop this type of behavior. Have you seen that? Is there something in statute that kind of that ties the judge's hands or anybody's hands that we should be looking at instead?
You know, Madam Chair, if I could, I mean, as you mentioned, yes, we do have the ability to require, well, I would say to request the different levels of intervention with the parents prior to getting to more serious situations. And so we do typically work through progressive discipline, and that involves parent shadowing, meetings with the parents, counseling and so forth, referral to services and things like that. But, in some cases, again, we're talking about a smaller group of students where for some reason or another, those strategies don't work. So, if you require them to shadow, but the parents don't show up, that's about the extent to which we can require that shadowing. And then we simply move on to a more severe punishment for the kid. And so that type of thing that I would suggest is the extent of our authority. But the other thing I would also, maybe as an idea, another example of what the courts do, which I think would be an interesting way to address this. The drug court, and especially for the juvenile drug court, that's where there's leverage of a more serious charge being used to get the students to participate in more significant, not just the student, but the family to participate in more significant activities, rehabilitation, therapy, and so forth. And it takes a longer, I know that it takes 6 to 12 months at least for some of these kids to get through the program successfully. And that seems to be something that we've liked and we've enjoyed seeing on the substance abuse side, because it really, it says, hey, you're in trouble and this is the violation, but we'll give you a chance to go to go through this program, but it's going to take commitment. It's going to take the family participation, and it's not going to be an easy thing. And then once you're done with it, we hope there's that you definitely have learned your lesson and definitely have put in the work to be able to return to school. And I've seen some of the students on the substance abuse side go through that and actually come back and finish and do a better job. So I don't know if that's something similar to look at, where it's really the leverage of the more serious consequence that enables the therapy and the parent involvement to take place.
All right. Yes, and I think thanks for bringing that up again. I think I heard one of the public defenders bring that up as they said a diversion program, like trying to work with the sponsor to incorporate a diversion type program, I guess. Do you believe that the solutions that the family court has come up with are effective? Are you seeing that? I guess I'm asking you, Steve.
Well, honestly, I remember when I was much younger, it seemed like back then we had a lot of juveniles that graduate into the adult system and then we have them forever. I don't know why, but in the last, 5 to 7 years, it doesn't seem as much like they're just going to be our clients until I retire. So, something's being done differently. And I don't know if the AGs, were they here testifying earlier? I know that they have programs set up with a pre-charge diversion program that it seems to be pretty effective. They divert, my understanding is upwards of 300 cases a year. And so, but they're getting services somehow. And I just wish I knew more about that program. And so maybe when hopefully you can ask them about it when they have their budget hearing. But it seems like a program that's, I mean, I don't know, maybe John has a better idea, but I just don't see like people staying, once they get in as juvenile, we're seeing them all the way through their adulthood.
I think there are definitely some successes in the program that we have. I think like almost anything, it suffers from a lack of resources at times. Sometimes there are waiting lists to get somebody into the right type of treatment. Sometimes there are issues, particularly in the person in need of service types of cases, with getting medication covered, long waiting lines for certain types of residential housing for the child to seek out substance abuse treatment and that sort of thing. Those problems are systemic, but all our practitioners and judges are operate in good faith, and I think have a lot of successes.
And so it just seems like, I mean, I know the court, they're starting to have judicial social workers, and I know we've been approved by the legislature to hire a social worker, and so we think that a social worker would really help us try to, at least the very difficult clients, help them get on their feet, and hopefully we won't have to see them again. And so I know that that's kind of a movement that many court systems are heading towards, just identifying and treating the ones that are the hardest to handle, the highest risk, basically.
That was going to be my last question. On those cases, as the superintendent has described, the very severe ones, the hardest to handle ones, the ones that we're talking about, serious behavior, I guess, and not easily solved. What, do you have any other recommendations for us, I guess, as opposed to leaving it within the court's discretion to try different things? Is there anything else that you think? Well, I hear now from all of you this incentivizing it with the threat of a serious penalty, but also allowing it to be diverted through the court as with the drug cases. But anything else for these serious cases? And I know that's, these bills were intended because the public was very much demanding. They want to see this behavior stopped. They want the riots between the kids to stop. They want the harm that minors are doing in villages to stop. And so I guess, yes, maybe in addition to what we've already discussed, are there any other recommendations that you've been working on or that you are thinking we should look at also to stop that serious cases?
Well, since you asked, one of the things that we really want to work on is there's a real problem with the deportation of FAS residents back to Chuk. They come to Guam, right, to have a better life, and then they find a job, and then they start having children. All their children are U.S. citizen born. So when they're deported, the father gets deported, the breadwinner, and the children remain, and they're in high school, and they're without their paternal influence. And so, hopefully in the future, we're going to try to propose going back to the old diversion program for family violence, which gave offenders a treatment, helped keep families together, and did not result in the deportation of first-time offenders. I mean, repeat offenders clearly, they will get deported regardless, but for first-time offenders of family violence, that program did work to keep families together, and hopefully we can resurrect it.
Okay.
I would say the only other thing that I can think of is, sometimes, obviously not every time, but I recall seeing cases where there were riots and major problems at DOE institutions, and the people involved may have been super seniors or a little older, and we do have a Youth Correction Act that's currently unfunded on the books that may have some use if it were funded for some of the older people, just probably right in the ballpark that we're talking about, if not a little bit older.
Superintendent, any thoughts on that?
I think, I don't know. I think that's a challenge, trying to deal with like we said, the minority, the very small minority of students in those highest risk categories. What I can say is I do want to echo the fact that you're seeing the numbers at DYA go down from where they were before, and hopefully that translates into less children, put into that school to jail pipeline. And the reason why is because we've been working with the courts and with the AG's office and with our police department partners and everybody to try to do more interventions at the school level. And I would say that for the most part, that helps us to try not to push kids out of the school system and into the correctional system. And when we acknowledge that success, the reality is that that's what stretches the resources at the school system, the counselors, the administrators, and the teachers, because we say, hey, you know what, we need evidence of intervention. We need to know you reached out to the parents and so forth. So for the most part, I think we're willing to do our part to try to not have the kids, get into that situation. It's only when you see things like we saw earlier this year, where this violence, where people are bleeding and injured and on campus, that's where we've almost lost our ability to figure out how are we supposed to be the experts in these situations where we've tried our best and that it's worked for most of our kids, but we still have a group that nobody knows what to deal with or how to deal with. So I think that's kind of why we're looking for help. I mean, I think this has basically been a cry for help from our stakeholders. And it's taken the form of parental accountability, as one of the strategies. But really, it's about saying, not a group of kids. It's going to take more than just DOE to figure out how we're going to address, their behavior and the consequences. So we're eager for them to be helped. And like I said, I mentioned things like ramping up our school-based, psychological services to try to give them a more immediate supports. A lot of partnerships in place, but it is a small group of students we're talking about, where I think we're almost at our wits' end trying to figure out how we're supposed to be able to solve this without the expertise that we know is out there. So we look forward to the experts helping us figure that part out, but we're willing to be partners in that.
Thank you. Yeah, I wanted to mention that we did invite, DYA, some of the nonprofits like Minyat Lu and Island Girl Power have also been invited. But I agree. So I will reach out to them also, but can I ask you while you're here, just one more question is, have you noticed anything that might be the underlying cause? Like if you had, what to speculate on the underlying causes. For example, I've received questions in my office on this and other bills, is it families is there some kind of pattern? Are they single parent families? Are they, families that just need help financially? Or is there any other trend that you might speculate about if you're in your experience?
I wouldn't speak to any sort of trend I don't think we've done that level of really hardcore analysis. I think that if you look at the anecdotal evidence, what we deal with in the school system is a reflection of what every one of us sees out in the community when we see families under stress. So whether it's a matter of the households where the parents are overwhelmed or not able to be present, where there's a substance abuse problem, and we know the substance abuse issues are very prevalent in our community. When what we worry about is in this time of stress with regard to the pandemic and the economic uncertainty, we're going to have a lot of kids bearing the brunt of those pressures, if they're the problems that are going to emerge at home and the stresses that are going to emerge with the family. So we really don't like to see these additional penalties or punishments being the only answer. But what we do know is that all these stresses that you see in the news outside of the school system are playing out in the school system as well. And I mean, and like Steve said, when you're talking about our Chuukese community, even more so when you see some of the challenges that are going on at the family, at the household level. So all of those contribute to the most serious cases where the parents, for one reason or another, are not present or are not able to supervise or control their kids. Let me just give just one anecdote. We had an issue with some of the break-ins that we were seeing over the break, the shutdown. I wouldn't call it a break. And when you talk to our police folks, they say, it's just an issue of kids just who aren't supervised, roaming around. They don't have the activities present. They're not, they're not in school. They're not in any activities. They're wandering around and they're getting into trouble. And so we all kind of have a role to play. But when you don't have that parental supervision or adult supervision, or present at all times, it's going to lead to those situations. So that's what we're seeing at the schools. So it just mirrors what we see in the community.
I see. John or Steve, anything to add?
No, I mean, I totally agree with the superintendent. I mean, I wouldn't give up hope. I mean, we deal with, there's so many kids going to school and they're drinking at school, right? And you're wondering, like, why are you even going to school if all you're going to do is drink? So, I mean, obviously, it's not as bad as if they just stop showing up to school. So they're partially engaged, and it's just, who knows, but at least they're partially engaged. It's better than them just not going to school and causing ruckus 24/7, so there's a little hope there, and hopefully we'll figure out some solutions.
All right, thank you. John, anything else before I turn it over to the sponsor of the bill?
I don't, Madam Speaker. I just wanted to thank everybody so much for engaging in this dialogue with the public defender representatives.
Well, thank you. And thank you, Superintendent and Ms. Borah. Ms. Borah, did you want to add anything before we conclude? I very much appreciate you being here and your testimony, as well as you, Steve. All right, so the sponsor of the bill, Senator Nelson, you may close on the bill. Vice Speaker.
Thank you, Madam Chair, and thank you very much for your thorough questioning, because you're an attorney also, so it's good that we have your expertise at this table. I'm very grateful for that. Yes, so I just want to thank everyone, Mr. Superintendent, Carla, Director Hattori, and Deputy Director Morrison. Thank you so much for spending a large amount of your afternoon here. We really would like to see something transform within our island community that really helps the children. And a lot of the I guess the behaviors that are violent behaviors, or was really the this legislation to be moved was just because we saw it in our locals, and in our brothers and sisters in Micronesia, and so we see this divide in our community. A lot of it is of ethnic biasness, and we don't have to be that way. That's, both of our cultures are focused on a mutual respect, and I think it's just the pressures from perhaps being new to Guam and having to start new, and then also the independence that our children are having to really fend for themselves most of the time. And like the superintendent said, this is a very small amount of the population within our schools that are creating these types of violent behavior, or rioting, or inciting, or instigating this kind of violence. And so we're just trying to move away from that, trying to see what we can do as an island community to just pause and regroup and restructure to help these children. So Director Hattori, I asked one of my team members to reach out to you, and hopefully we can schedule a meeting next week to discuss the impacts of this bill and see how we can improve it so that we don't conflict with any existing statute. Thank you, and thank you again to my colleagues for being here and giving your input as well. It was a big help.
Thank you. I wanted to invite anyone else who would like to submit testimony. We will allow at least the 10 days that the superintendent has and the board has requested. So I'll call for it for 10 days from today to please submit testimony. And there being no additional individuals to present today, the committee will consider these two bills, 277 and 310, duly heard, and the time is now 3:58 p.m. Thank you again. We're going to move on to our third item on the agenda. If anyone needs to excuse themselves, please. Thank you. So the third item on, thank you. The third item on our agenda is Bill number 275-35. It is introduced by the Committee on Rules at the request of Imagahagan Guahan, the governor, in accordance with the Organic Act. It's an act to amend subsection A of 80.70, Chapter 80, Title 9 of the Guam Code annotated relative to prohibiting parole for violent and sexual offenses. I'm gonna just paraphrase the bill myself here because there's no sponsor to introduce it. This bill would prohibit the parole of any violent offender and would add third and fourth degree criminal sexual conduct to the list of violent crimes not eligible for parole. Current statute allows violent offenders who have served at least 85% of their sentence to be considered for parole. We have the public defender again signed up to testify. Mr. Tori? Mr. Morrison.
So, Madam Speaker, I think the area of parole and parole eligibility is a somewhat confusing area of the law for a lot of people and even some of the practitioners, because a lot of hearings at this level are done without an attorney present. So our office, for instance, doesn't currently staff an attorney to represent people at their parole hearings, although we would like to see that change in the future. So for the time being, the current law is for an average crime that's non-specified, the offender has to serve 2/3 of their sentence. For certain drug offenses, the individual has to serve 50% of their sentence before qualifying for parole. And in the case of these violent crimes, they have to serve 85% before qualifying for parole. That parole is governed on their fixed sentence. After they're released, they're still subject to supervision that we again call parole. So for the person who's released after serving 85% of their sentence, there's still going to be, in all likelihood, 3 years of parole supervision for them. I think what I would say in opposition to this bill is that I believe that there is some benefit for having somebody go through the process. If all things are working correctly, it means that the individual has served 85% of their sentence. They've been meeting with their parole officer at DOC throughout their sentence, and they have a plan for the person's release. DOC knows where this person's going to be residing, who lives in that household. They know if they have job prospects. They know what their transportation is going to be like. They know who is going to be living in the home. So all these things have gone into place before a parole hearing. And it's only after that parole hearing, if the board is satisfied, that the individual can be released after serving 85% of their parole, in which case they're still going to have 3 years of parole in all likelihood. So I think we do gain something by having the person go through that entire process and working with their parole officer and qualifying by virtue of staying out of trouble while they were in custody and having a good solid plan in place that the board can be comfortable releasing them after serving 85% of their sentence. I am not in possession of any recidivism rates that would give me confidence that there's some logical reason to include these two sort of serious but lower level offenses that are currently considered violent crimes. I still think that if somebody's served 85% and has a very good plan in place, that they should be just released on normal parole supervision, which is still quite onerous. I don't think I have anything more to add than that.
Could I just get you to reiterate when you said these two serious but lower level. You're talking about the 3rd and 4th degree criminal sexual conduct offenses?
Right, that's as I understand specifically that this wants to add those to violent crimes, and it wants to take away any discretion from the parole board to release someone after serving 85%.
Okay, all right. The fiscal impact, according to BBMR from this bill, they are administrative in nature. It is anticipated that no direct fiscal impact to operations at the Office of the Attorney General, but that these proposed amendments, according to BBMR's input from the Office of Attorney General, the proposed amendments may create ambiguities in law and subsequently new cases. Thus, may be required to utilize more resources to handle additional new cases. Due to uncertainty of how many new additional cases, BBMR is unable to determine the approximate financial impact at this time. It makes no mention of potential impact to DOC operations with the prohibiting of parole of offenders. And that's about it from BBMR. Okay, so colleagues on the bill, any questions, Vice Speaker? And Senator Perez? All right, anyone? Senator Taitakwi?
Thank you, Madam Chair. You know, I appreciate, again, Mr. Morrison, for you being here. But, you know, you provide an opinion, and a lot of it doesn't have data to back it up. We're asking you, have you seen these, you know, circumstances, and can you give us some more information to back up your opinions? So I'm hoping that maybe, you know, the opportunity arises here where you can actually provide us some data. Other than that, you know, I have nothing else. Thank you, Madam Chair.
Senator Marsh-Titano?
Seduce Masi, Madam Chair. So it was very important to hear from the public defenders whether the new types of criminal conduct seem serious enough to be added to this listing. And I also wonder, so if I'm reading it correctly, that it's taking out that if they have completed 85% of their sentence, then they could qualify for parole. So it's taking out that option completely for these violent offenders. And certainly, I mean, we've been talking about safety all day. We want our island as absolutely safe as possible. But I do wonder, and it'd be important to hear from those that have expertise, are there benefits? You talked about, Mr. Morrison or Attorney Morrison talked about the benefits of going through the process. Do you mean that by having a process like this in place, there can be benefits as far as providing incentive for good behavior or incentive for completing programs so that they can potentially qualify for parole and have a good parole hearing? What did you mean when you said the benefits of the process?
I think that's the. Is there a feedback issue? Oh.
Yeah, if you can repeat that because it broke when you were replying.
Okay, so the motivation here, it's always been considered discretionary parole, meaning that to get 15% off your sentence, the Department of Corrections Parole Board has to have met and decided that you have a viable plan, that that you're going to be safe in the community, and that they should release you. Part of what they will look at is how well you've done in custody, if there were programs that you availed yourself to, if you seem sincere, and that's the process. You're essentially sitting down for a job interview and convincing a board that you're up to the task before they just give you the job 15% later. So that I think is the value in the process, that it is discretionary. people can be turned down for it, but I think it gives them something to prepare for, and it gives the board, prior to the person's unconditional release on parole, the opportunity to assess them and their plan and determine if they're going to be safe in the community. And I mean, I know there have been certainly failings, but I believe that there's value in the process, and that's why we've historically had it.
So that I appreciate your spelling that out. That I can see the value in what you're saying. Do you have the ability to explain to us what a viable plan might look like, so that we understand it? Is it working towards a job? Is it having somewhere to stay? Is it elements like that?
It is elements like that. That is certainly how I understand it. How my clients have reported back to me on how it occurs. That they need to have a plan for work or education, or what they're going to be doing for their family, where they're going to be residing, who lives in that place. Parole should, in all likelihood, and I believe they do, go out and do a home assessment like we would in a variety of other contexts, and make sure that what the person's told them is accurate, that they actually have a place to stay there, that they're welcome in their family, that the family connections haven't deteriorated to a point where they're going to be a burden. And I think all those things need to be considered before the board makes a careful decision. This would just take away the board's ability to do that.
So are you also saying that if we just insisted that they serve 100% of their time, they can leave on that day with 0 plans in place and having none of those things that you outlined sort of assured by the community? I guess I would imagine maybe there's a certain amount of supervision. Is there typically supervision like that?
There is. The individual would, in all likelihood, if this were a felony, be subject to 3 years of parole with a parole officer at that point. I looked at our parole statutes prior to offering any testimony today, and they seem, some of the numbers listed in them gives me a reason to believe they must be pretty old, because parole is told to essentially give the person an outfit to wear on the way out the door and up to $25. So if someone completed 100% of their sentence, we could expect them to walk out of prison with some clothes and up to $25. Of course, parole would be expected to still supervise this person and supervise them closely, but there wouldn't, until there's a parole violation, the person wouldn't be incarcerated.
So with that, and again, thank you for the helpful information. With that, are there recommendations that you would have? You had mentioned some failings. Are there recommendations that you would have, maybe instead of, if it makes more sense to, instead of taking out this option completely, what if we formalized aspects of it? That, I mean, do you see any value to that, or is there more value into leaving it flexible? I know we've had some roundtables that I think have addressed some of these issues as well.
I guess this is, I'm speaking against the bill, but I am not sure that the bill's sponsor had information on particular recidivism rates for these 2 crimes or not, that gave them pause to think that that nobody should qualify for a 15% reduction in parole just by virtue of their 3rd-degree felony conviction.
Right, and so it is adding those other 2 in, right? So no thoughts on formalizing any part of the parole process if we were still wanting to keep some qualifications of the parole in?
Well, Senator, I'd be more comfortable if parole were here to answer that question in particular about, their particular rules and regulations. But if things were formalized relative to a release plan and there needed to be a statutory vehicle for that, I don't think there'd be any objection here. I believe those things are required to take place already, but they're non-statutory. Perhaps they're just the rules that DOC has come up with for when they're going to release someone on discretionary parole.
Sedgwick Mossy, Madam Chair. That was basically all I had at this point.
Thank you very much, Senator. Did I get everyone? Hello, Senator Taitagui, did I call? I did already call on you. I guess that's everyone. Senator Muñoz, I'm sorry. Senator Muñoz.
Thank you, Madam Chair. So what I'm looking through the bill, this bill doesn't address the Safety Valve Act. And I know there were a couple of bills that were introduced, one being one of mine. There were a couple of bills that were introduced that created an exception to that Safety Valve Act. And one of the bills that I did introduce on 125-35 also removed the applicability to the Safety Valve Act. And so I'm wondering if, maybe Attorney Morrison would have any comments on that about this bill not addressing the Safety Valve Act?
Senator, I know the provisions of the Safety Valve Act read, notwithstanding any other provision of law. So clearly, this law, I don't think by itself would seek to alter the makeup of the Safety Valve Act. I think it would still legally be applicable and on a case-by-case analysis. I'm aware of the concerns relative to certain levels of CSC crimes and the thought that maybe those are going to be safety valved. I can't tell you in practice, that has not been my experience. That I think the times that has been brought up to judges, it has been fairly fruitless. The judges have been very cautious to impose safety valve sentences for people convicted of those serious offenses.
Okay, thank you for that comment. Thank you, Madam Chair. I have no further questions, but I look forward to the discussion, when this bill gets heard. Thank you.
Thank you. Thank you to all my colleagues, and thank you to Attorney Morrison. When you mentioned the word failings, that there have been failings despite the process, being supposed to be equipped to assess very well whether people are ready to be let out on parole, whether they will be successful, an assessment of their job ability, their mental health, their family relationships, and everything that would lead for them to be successful. But you're right, there have been failings. And in fact, recent ones, the beginning of our term, really, we began with a release of a person who had been convicted of sexual conduct offenses, released on parole, and another offense, and this was against a minor, so it was very egregious for the community. So I guess I can say I understand the reaction, that this bill is intended to prevent any release of violent offenders, but I agree with you that the parole board has got to do its job. I've tried to put in some laws this year that would require them to look at certain, all the assessments that had been done, the pre-sentence reports, the assessments while people are in prison, to require additional assessments for criminal sexual conduct cases, so that just to give the parole board additional tools to really determine for this type of case and this type of offender, are they a risk to the community, or are they, should we take a chance on them, letting them out and becoming successful? We did invite the parole board to attend today. So I haven't heard back from them, but I will follow up, of course, and try to get their input on this bill. But this is a parole. So the whole idea behind parole, my understanding, is to incentivize good behavior in prison, rehabilitation, and to, just go forward with that. If they're not sentenced to life, if they're not denied parole by our statutes, that they are we want them to be rehabilitated. We want them to become successful. I think I speak for some of my colleagues in the legislature. I know we've found it very challenging to believe there's a successful rehabilitation based on what we have seen, right? I think the recidivism rates were quite high. I don't have them in front of me, but I'm gonna find those also. But of course, yeah, I'm glad you're here, Mr. Morrison. You're giving me some hope in the process that we can still have some faith in it. I just think we really got to hold people accountable to really do that analysis and get the tools that they need to do rehabilitation in the prisons and to do analysis before parole is actually granted, and not to allow risk to the community if that is something that is in front of them. I don't know, but I do very much appreciate your testimony. It's been very helpful for me to analyze these bills. And if there's nothing else on these bills by any of my colleagues or you, Mr. Morrison, I'm going to move on to the next one.
I'd be prepared to move on. Thank you very much.
All right, thank you. Okay, so sorry, let me get the number. So the hearing on bill number 275-35 is concluded, and we will move on to the fourth agenda item, which is bill number 278-35. This is another bill introduced by Committee on Rules at the request of the Imagahagan Guahan, the governor, in accordance with the Organic Act. It's an act to amend subsection B of 60.80, Chapter 60, Title 8 of the Guam Code Annotated, relative to prohibiting plea deals without reasonable proof of victim notification. We've received no written testimony on this bill. I might as well add this to the record at this point, that Bill 278 is one of several bills that were transmitted to the legislature, three of which you've seen today, referred to my committee. These were referred to by the governor as the Safer Guam Initiative. The bills were submitted after a series of public safety meetings with residents around the island. So this one was received by our committee right before the pandemic, so we're trying to have a hearing on it as promptly as we can. So this bill amends the plea bargaining statutes to require that no plea agreement shall be accepted unless the prosecution can provide evidence that the applicable victim has been notified of his or her rights and has been consulted and advised. I want to note that in another section of the code, section 160.45 of Title 8, Guam Code Annotated, it mandates that victims have the right to receive notices. This is part of the victims' rights statutes, and it says victims and surviving immediate family members shall be informed of their right to receive notices and the procedure to receive notices pursuant to this chapter. Victims and surviving immediate family members shall have the right to request to receive notices provided for under this chapter by filing a request with the Office of the Attorney General at any time. After a request has been filed, the Office of the Attorney General shall be responsible for informing other departments or agencies of the government to provide further notice as may be provided in this chapter to the victim and or surviving immediate family members as the case may be. We've continued to hear complaints at different hearings that we have had from victims where they said they have not been informed of the deals promptly by the Attorney General's office. And we also have heard in recent news from the Attorney General's office of an electronic system that they have implemented called VINE, V-I-N-E, which is supposed to increase notification of victims. I was hoping, of course, that the Attorney General's office would be here so they could specify their process for notifying victims, whether an additional statute is necessary versus the one that's already in the law, and you know what additional I don't know assistance by the legislature is necessary for these victims' rights statutes to be implemented. But we do have the public defender signed to testify. Again, thank you, Mr. Morrison, for your patience in being here all day long and for your assistance. It's been very helpful, and you have the floor now.
And thank you, Madam Chairperson. This bill is unlikely to affect the clients that my office represents. So I'd really like to be here in more of an informative role. And what I can tell you is that since I've been practicing law in Guam since 2008, I've seen victims repeatedly notified in court. Not only by the Attorney General reaching out on their own accord, but it's the second question that comes up every time we do a plea agreement. The first question is, do you have one? And when we do, the judge, all of our judges, in recent years, without exception, then direct the question to the Attorney General: has there been victim notification? Now, that's not to say that that operates perfectly, that their phone might have been disconnected, or that efforts to reach out to them were not successful or something. But in practice, this is something that's taken incredibly seriously, in my view. And I had been informed that since Attorney General Camacho had taken the helm at the AG's office, that they had taken steps to contract with the Victim Information Network Everyday Service. And that's a service that I'm familiar with from practicing in other jurisdictions, and was used to show, to alert the community, victims in particular, when someone was going to be released, and also where the person was being housed if it was a system where there were multiple facilities. So that worked very well, and I'd certainly applaud the Attorney General for those efforts that I've seen be successful in other jurisdictions. So this really seems to be adding an obligation that already exists, that I've already seen taken incredibly seriously in my day-to-day practice.
Well, that's great news. And so you told us what VINE stands for. So that's Victim Information Network. What was the last part?
Sorry, I think I might have screwed it up. It's Victim Information Notification Every Day.
Every day. All right, thanks. Yes, and it was, I don't know if my colleagues recall, it was pretty much just earlier this year that he announced that this program is now available on Guam. And if I understand correctly, it notifies victims who have signed up to be notified by text alert of whatever the statute mandates. And they were trying to hook it also up to DOC to alert them on release of prisoners from the Department of Corrections. And I think that was one of the later legs that they were going to add on, and I'm not sure the status of that last part. Are you, Mr. Morrison?
I'm aware that I think the current service that they wanted to contract for was just a phone call or text notification, and that some of the other services might be further down the line. That's as I understand it. And I just wanted to reiterate, as far as the notifications for plea agreements, I mean, this this rabbit hole goes relatively deep. I mean, I've been in court and the judge has made us, in a case where someone has shoplifted a 12-pack of beer from the Circle K, the judge has required that we come back and make sure that the victim is notified. So it was, calls to the managers of that particular Circle K to let them know of the change of police. So yeah, just to reiterate, it's something that's, I think, taken quite seriously.
All right, great. That's good to hear. Senators, anyone has a question? If you could wave your hand, Senator Taitukui.
Oh, Mr. Morrison, I'm glad there's one bill that you're okay with. I'm just joking. I mean, it's the end. It's the last bill. That's the best bill. But I appreciate, I have to admit, I would love some data from you, just to back up your opinion, like I said earlier. But this bill obviously is, I don't even think this bill is really needed since the AG is already working on it. And but I have to commend you. I greatly appreciate you being here, especially for us, to have somebody, another attorney. We rely so much on Senator Terlaje to answer some of our questions, but I'm sure she's happy to have another attorney on board to help us out as well. Again, I greatly appreciate, and looking forward to Alaska, one day. You mentioned a lot of your information came from Alaska. So again, I appreciate it. And Madam Chair, excellent job today with all the information you're providing. I'm just very disappointed in the fact that these bills coming from the administration and nobody is here to support these bills at all, to provide any kind of testimony on this. But as a good senator that you're doing your due diligence in hearing the bill, so I greatly appreciate that. And Sidus Masi to everyone and my colleagues that stuck it out as well. Thank you.
Thank you. We were informed by the Attorney General's office today that they would be submitting comments or testimony on the bills. But Senator Taituno, any comments or questions?
Sidus Masi, Madam Chair. So I'm just weighing out in my mind the good discussion that we've had about the fact that there is another section of the law that says that victims should be receiving this information. As you mentioned at the public hearings, we were hearing that at least for some time, it didn't seem to always be happening. And it is good to hear about the fine. And so I guess the last part that I'm weighing out in my mind is, even if we have the fine in place, maybe it's the historian part of me, things come and go. Things that maybe seem very permanent do kind of come and go, and we've seen that software has to be changed and so forth, or may run into issues. So does it still make sense in the big picture to have something that additionally asserts here, this must happen, it's clear to all of us, no exceptions, Vine's working, the Vine's not working? Does it make sense to have one more place where it just assures it, makes it clear to everybody that this is a standard that must be abided by?
I can't speak for the Attorney General on this one, but I believe from my perspective, it would just kind of create a redundancy in the law that this is already something that exists. It's something that the Attorney Generals are expected to do, and it's something that judges will not accept a plea agreement unless they can verify that they've done it. And that's just been my experience for the last 12 years, but I'm hard pressed to think of an example, certainly not a serious case, where the judge didn't inquire as to this, because they universally seem to recognize how important it is, particularly since the passage of the Victims Information or the Victims' Rights Act.
Sidus Masi for the information. It helps me weigh it out a little bit. I do want to wait and read what the Attorney General's opinion is or what their statement is. And sometimes we do make those statements that it seems to be a good thing to put something even if it's in a second time or third time, just for that clarity, or so it doesn't get missed over. Like you said, it's such an important thing. We would not really expect it to be looked over in a happenstance sort of way. So I appreciate your weighing in on that, and it gives me another bit of information to help me make my final decisions.
Thank you. Any other senators? Senator Muñoz?
Thank you, Madam Chair. Basically, no questions, but just to thank Attorney Morrison for pretty much hanging out with us all day long today and sticking it out and answering any questions that we may have, whether you're in support or against the bills. So thank you very much for that. And thank you, Madam Chair, for holding the hearing on these bills and, all the bills that we've introduced, and looking forward to more of these discussions. And also with the AG's testimony on these too, if you can share that with the committee, I would really appreciate that. I'd like to see where they stand too. And thank you very much, everyone. Thank you, Madam Chair.
Thank you, Senator. I'm very glad for you all that have joined us and stuck with us. Senator Perez, Vice Chair, would you like to add anything?
I just, out of curiosity, should this bill pass, are there any impacts if the plea agreement has not been, or the victims have not been notified? I mean, it doesn't state what the impact would be. Just wondering what it would be if there's anything in law that currently exists.
I think this statute in particular, or this bill would assume that no plea could go forward unless there was notification. So I don't think it could ever be the chance that anyone would seek to undo a plea that had been passed because there'd be no plea.
Okay, great, thank you. That's all my questions. Thank you so much.
Mr. Morrison, anything to conclude?
No, Madam Chair. Thank you very much for the opportunity to offer testimony on these important bills, and I hope you all know that you can reach out to my office at any time for any assistance on this sort of legislation. Thank you.
Well, I want to thank you, and please extend my thanks to your entire office, because I know that if you are here, that means they are covering over there, and it's an additional work